Thank you everyone for joining us on this Valentine's Day. I'm sure there's nothing more romantic that you all could have thought to do than to be a part of the immigration law competition on this Sunday. So we thank you all for joining. For those of you who are a little less inclined to celebrate Valentine's Day, we thank you for joining us as well. Hopefully this is a welcome reprieve from trying to figure out whether or not the young lady from Louisiana was going to get Gorilla Glue out of her hair. Hopefully you will find this a little bit more intellectually rigorous than that. My name is Javante Mason. I'm the editor-in-chief of Moot Court Board, and welcome to the 16th annual National Immigration Law Competition hosted by Moot Court Board at NYU. This final round is truly the culmination of thousands of hours of effort put forth by hundreds of individuals over the course of this past year. That is not hyperbole, it is a fact of circumstance. This last year, to say the least, has brought about more tumult than any of us could have ever imagined when we began planning this competition last March. Despite great personal hardship for many of us on Moot Court Board, our ILC executive editors, Chang Han and Dylan Lear, have devoted hundreds, if not thousands of hours of their own effort into making this happen. As the principal organizers of this event, Dylan and Chang recruited over 200 practicing attorneys to serve as preliminary round judges, both this past Friday and Saturday. They worked with our problem writers, Miriam Beal and Leonie Koch, for several months to write the problem. They've also been in contact with 27 teams over the course of the past several months to get them prepared and ready for this competition as well. And to say nothing more, they also ran the entire competition this weekend up until 1 o'clock in the morning with me on Friday, and up late last night as well. And we've been working at it again this morning. So their efforts have really been extraordinary. And I thank them so much for all of their efforts to make this happen on behalf of everyone in attending, as well as Moot Court Board, our judges, and our competitors. It is also necessary that I express a little bit of gratitude to our problem writers, without whom there would be no competition to have. The problem this year that Miriam and Leonie wrote is socially conscious, politically relevant, and it forces legal practitioners to engage in a very complicated area of the law at the intersections of immigration and criminality. As someone who wrote last year's problem and know how difficult it is to try to strike all of those points, from the bottom of my heart, I can say that you two have done a masterful job this year, and thank you so much for your efforts as well. And also, it is necessary to, again, thank those 200 attorneys who joined us this weekend, the 27 teams who joined us this weekend, the efforts of NYU Law's Office of Student Affairs, as well as the IT department, whom without their fiscal and technological support for the past several months, we would not have been able to have navigated Zoom at all this weekend, much less this morning, as we also dealt with trying to make sure that all of our technology was working as we needed it to. So thank you to them as well. And last, but almost certainly not least, I would like to extend a thank you to our panelists of federal jurists who have joined us this afternoon and for one this morning. Thank you so much, Judge Julio Fuentes, who has joined us from the far-flung territory of New Jersey. He is a federal judge on the United States Court of Appeals for the Third Circuit. Joining us as well, we have Chief Judge Deborah Livingston, who serves on the United States Court of Appeals for the Second Circuit. And a special welcome as well to Judge Morgan Kristen, who serves on the United States Court of Appeals for the Ninth Circuit. Thank you all so much for joining us this afternoon. And I will now turn it over to the ILC Executive Editors, who will provide some brief remarks as well and a little bit of background about the problem to get us started. Dylan?
Yes, thank you so much, Javante, for that wonderful introduction. Before we proceed, we want to extend a very special thank you as well to Javante Mason, our editor-in-chief. On top of all the time that we spent preparing for this competition, Javante as well also spent countless hours helping to bring everything to life. We also want to give a special named shout out to Bailey Springer and Nicole Oliver, There are two of our managing editors here at NYU Law Moot Court who also dedicated the last few months helping us organize this entire event. And I will allow Chang, my fellow executive editor, to speak a little bit about the problem.
Allow me to set the scene for this year's problem. We are here before the Supreme Court of the United States to hear the case of Achilles Politis versus United States. Achilles Politis, the respondent in today's case, is a foreign national who came from the fictional country of Mount Olympus and lived in the fictional district of Troy, which is in the United States. Mr. Politis was deported in 2017 for committing 2 crimes of moral turpitude. In 2019, Mr. Politis was arrested for illegally re-entering the United States.
So the 2 issues that we are going to hear today and which are before the Supreme Court are, first, whether a non-citizen's failure to register as a sex offender is a crime involving moral turpitude that makes them subject to removal. And second, whether non-citizens in removal proceedings have a due process right to be made aware of discretionary relief from removal. And with that, you should all have some background information on what you will be hearing today, and we will return the time to Javante, our editor-in-chief.
Thank you, Dylan and Chang. So without further ado, the reason why we are all here, let's get the oral argument started. I will now turn it over to the clerk of the court, Alexandra Gray, to bring the court to session. Thank you.
All come to attention for the Honorable Justices of the Supreme Court of the United States of America. Oyez, oyez, the Supreme Court of the United States is now in session. Justice Julio Fuentes, Chief Justice Deborah Livingston, and Justice Morgan Christen are now presiding. Justices, the petitioners have reserved 2 minutes of their rebuttal time, and so their argument will take 28 minutes. After petitioners, respondents will argue for 30 minutes, and that will be followed by the petitioner's 2-minute rebuttal. Chief Justice, whenever you're ready, please check that the parties are ready to proceed, and you may instruct the petitioners to commence argument.
Thank you. Thank you to the clerk. I see that all parties are assembled and ready to proceed, so I'm going to dispense with calling the calendar. We have just a single case on the calendar today, United States v. Politis, and we are ready to proceed. We'll hear from the petitioner.
Thank you, Madam Chief Justice. Good afternoon, Your Honors, opposing counsel, and may it please the court. My name is Richard Rosen, and along with my co-counsel, Timothy O'Shea, we represent the petitioner, the United States, in this proceeding. In August of 2015, Mr. Achilles Politis was convicted of statutory rape after engaging in a sexual relationship with a minor. Mr. Politis pled guilty to this offense, serving 9 months of a 1-year prison sentence. And one of the conditions of his conviction and subsequent release was that he register in the county's sex offense database, not just one time, but every single year. Mr. Politis understood this condition, signing a written agreement to that effect, and complied with it the first year that he was eligible to do so. But the following year, Mr. Politis failed to renew his sex offense registration, claiming that he never received a courtesy reminder from the county in the mail and that he had forgotten.
Mr. Rosen, you mentioned that he had registered on a sex offender registration form. Looking at the record, the 13th Circuit seems to have determined that the district court shouldn't have considered that. Is that a matter that's properly before us?
Yes, Your Honor, that speaks to the frameworks which we are considering here, both the categorical and the modified approach. You'll see that the 13th Circuit applied a different version of the modified approach, which entails consideration of extenuating circumstances and the immigrant's record of conviction, while the district court's modified approach just looked at the statute in the abstract. Now, as I will explain to you today, there are various gradations of the categorical and modified approach. And the one which we will advocate for is the one that the 13th Circuit applied, which entailed consideration of the specific circumstances surrounding Mr. Politis, as well as the statute and his record of conviction. But just
So typically when we look at the categorical approach, that the whole point is that we're not considering facts, right? Under the Taylor case, we're just looking at matching element to element, if I could. So could I just stop you to get a little bit better explanation of the version of the modified categorical approach you want to use, and in particular, I'm interested in whether or not you're going to consider or did consider whether the statute is divisible.
Yes, Your Honor. To answer the former part of your question first, very few courts today actually subscribe to a pure single-step approach of the categorical method, which entails just looking at the statute in the abstract. In fact, we, the government, could not identify a single circuit that uses the one-step approach. All circuits adhere to some variation, a 2 or 3 step review.
So if we're going to focus on my second question first, if I could, please. My second question was, are you considering whether the statute is divisible? That's my first question. I'd like you to answer that first before we launch.
Yes, Your Honor. We are considering that 16686B is divisible, as registrants have to provide various information.
Okay, so if that's the case, you've decided it is?
Yes, Your Honor.
Okay, and then which documents are you, to get back to Chief Justice's question, which documents are you considering, please?
The immigrant's plea agreement, as well as indictment, as well as his agreement to adhere to the sex offense registration database.
So you're only talking, then it must be the case that you're only talking about the one crime for failure to register, and not the crime for the conviction for the statutory rape charge.
That's correct, Your Honor. Under federal law, 2 crimes of moral turpitude are required for deportation. The respondent already concedes that he committed 1 when he was convicted for statutory rape. We are only concerned with the legal question of whether his failure to renew his registration is a crime of moral turpitude.
Right. I don't want to take a lot of your time on this, but I recognize he concedes he committed it, or rather that it is a crime involving moral turpitude. But does he concede that crime qualifies?
Yes, Your Honor, he does. In fact, much of the case law that respondent cites in their brief, such as Bacor in the 8th Circuit, Plasencia in the 9th Circuit, and Epigene in the 10th Circuit, universally holds that statutory rape is considered reprehensible to all, not merely some people. And the respondent does not dispute that the first offense is morally turpitudinous. The only consideration from their perspective is whether or not the second offense is an administrative transgression or something that cannot be separated from the first offense. But just to be clear, we are advocating for the 13th Circuit approach in this case, in which we are considering not just the statute, but the conduct of the immigrant and the immigrant's record of conviction. And this is the best approach because just looking at the statute in the abstract is insufficient in order to understand the case-by-case analysis under which each immigrant's conduct should be viewed. So under the 13th Circuit standard, Your Honor, there must be a realistic possibility that 1, the state would apply the statute to conduct which is not reprehensible, and 2, which was not undertaken with evil intent.
Am I misremembering the record? I thought that the 13th Circuit held that the district court shouldn't have considered the sex offender registration form. Am I misremembering that?
No, Your Honor. No, Your Honor. You are correct.
But you want us to consider that form?
Yes, Your Honor. Just to be clear, Judge Agamemnon during the immigration hearing declined to make a finding of what the intent was of Mr. Politis, whether or not it was willful or accidental intent in his failure to re-register. Therefore, it's the duty of this court today to evaluate that circumstance and decide whether or not, based on the record and based on the documents under the modified approach, he did act willfully or accidentally in that respect. Therefore, we must look at the record of conviction as well as the plea agreement. Now, the first pillar of the modified approach is reprehensible conduct. And what that means is acts which shock the public conscience. So the court in De Silva Nito v. Holder held that for an act to shock the public conscience, it must be viewed as reprehensible to all, not merely to some people. And what acts shock the public conscience? Well, as I mentioned a moment ago, the court in Bacor v. Barr held that statutory rape does shock the conscience to qualify as reprehensible. And that case, much like this one, also involved a sex offender's failure to register for a database. And so the 8th Circuit held that this was a CIMT, as well as the 10th Circuit in a comparable case in Epigene.
But couldn't the statute here be violated by someone who accidentally wrote down the wrong license number when they appeared to register or got the model of their car incorrectly? I mean, that sounds more like an administrative duty, not a reprehensible dereliction of duty.
Yes, Your Honor, we have two responses to that. Firstly, under the categorical approach, which I believe you are referring to with accidental violations, theoretically, it could be violated that way. But in practice, 16686B would never actually be prosecuted. And respondent has not put forth any evidence that such an accidental mistake has ever before been prosecuted in Troy or other jurisdictions, making this categorically a crime of moral turpitude. And second, we want to make a distinction for you, Madam Chief Justice. Not all administrative offenses were created equally. And this is something the court in Bakor v. Barr states, and I quote, "Not all failures to comply with administrative requirements carry the same moral gravity." So you are correct that administrative transgressions may not rise to the level of crimes of moral turpitude if the licensing provision is, say, for the maintenance of a motel. It would not carry the same solemnity as forgetting to register in a sex offense database. And that is why this difference necessitates the need for a modified approach by which you can analyze the surrounding circumstances.
That's a whole lot, a slippery slope that involves considering the facts. And Taylor doesn't allow us to consider the facts.
Well, Your Honor, most of the circuits subsequent to Taylor, which I believe was decided in 1990, again, even though they claim that they're applying the categorical approach, which just looks at the statute in the abstract, they are in fact weighing the record and the circumstances, which looks more like the modified approach through a 2 or 3-step formulation. And we want to reemphasize that we are not advocating for the categorical approach in its application to this case. We think that the 13th Circuit puts forth the best framework in the modified approach, because we want to turn your attention to the underlying fundamental public interest between sex offense databases to begin with. It's not just a regulatory or licensing provision, as the respondent might attempt to put forth today. Instead, is a critical apparatus to ensure public safety by alerting the population of the potential danger posed by sex offenders in the community. Failure to update that information places young, vulnerable populations at risk.
Perhaps, Mr. Rosen, separately, when I look at the sex offender registration statute, I don't see a mens rea requirement. And when I think about the underlying offense in this case of statutory rape that triggered the response's need to register, that is also a strict liability offense. So how can this possibly be a crime of moral turpitude when there's no mental culpability requirement at all?
Yes, Your Honor, you are correct. The statute does not explicitly mention a mens rea, and that is certainly a potential weakness in the statute. The government submits that it respectfully is not the court's job to rewrite or second guess the statute enacted democratically by the people of Troy. And if we look at the language of 16686B, it requires that registrants provide various information, such as addresses or their place of employment. This is a little bit different than plain mistakes, say a typo on an address. And this is part of the determination that the district court made on page 14 of the record when they addressed this mens rea issue. And on that note, I want to turn your attention to the second prong of the modified approach, which is realistic probability of evil intent. For an offense to be categorized as a crime of moral turpitude, the crimes must be committed with scienter, meaning with the knowledge of the wrongfulness of the act. So the key question under this section of the modified approach test is whether the surrounding circumstances indicate that Mr. Pleadis acted with scienter in failing to renew his registration. The respondent would argue that he accidentally violated the statute.
Well, he says he moved, he registered once, a year went by, he moved, he didn't get a reminder, and he just forgot. So negligent at most, it seems to me, if assuming those facts are correct.
Yes, Your Honor. Now, you are correct that he never received a reminder to re-register. However, first, the reason why Mr. Pleadis never received this courtesy reminder is because he changed residences, a fact that he did not think necessary to convey to the city. And secondly, it is a reminder, which by definition is only necessary to alert your attention to something for which you have already been made aware. For example, a reminder to pay your mortgage or your rent. If your landlord or your bank asked for either of these, no reasonable person would respond that they never received a reminder to pay. We want to emphasize that it's a courtesy by the county. Mr. Pleadis already agreed that he would do this when he was convicted.
And he did do it. That's your real problem, right? He did. He did register in the past. That seems to me to be consistent with somebody who's trying to comply and who goofed, made a mistake.
Well, Your Honor, subject to Exhibit B, number 4, page 39 of the record, Mr. Pleadis agreed not that he would register once, but that he would register every single year. And if we return under the modified approach, if we return to the record, first, Sex offenders are informed both at the time of their sentencing and again prior to their release from prison that they're required to register in person in the database. Second, he signed a document agreeing he would do this both both during sentencing and at the time of his conviction.
All right, what you're establishing, counsel, is that he knew about the requirement, and that's not contested here. The question is whether his failure to register or to update is necessarily morally reprehensible. Does it really necessarily rise to this standard?
Briefly, Your Honor, in respect to the former part of your question, respondent actually does contend that he knew about his obligation to register. Respondent contends that he.
That's what I said. It's not contested. He knew that, right?
Yes,
Absolutely.
absolutely.
That's what I said, counsel. That's my point. It's not contested. He knew, but how do you get from knowing about the obligation to this much higher burden that you have to show?
Well, under People v. Cox, the court stated that when the respondent knows something and forgot, forgetting presupposes knowledge. And because the respondent acknowledges that he forgot to renew his registration, he's admitting that he knew it in the first place, which would satisfy the willful intent component of the second pillar of the modified approach.
Sounds, Mr. Rosen, like a strict liability offense. Once you don't register, that's it, you're done. Even if you forgot, even if you might have had an accident that prevented you from registering on time, you have it set up as strict liability. Once you get to this date, if you don't register, you're done. Is that the case?
Well, Your Honor, we would say that federal law is reasonable. You won't be deported for one crime of moral turpitude if you forget to comply with an obligation once. 2 crimes of moral turpitude are necessary.
How do you know that that's not what happened in this case?
Respectfully, Your Honor, Mr. Politis was convicted for statutory rape once, which was his first crime of moral turpitude. And by failing to re-register, that was his second crime of moral turpitude. Now, under People v. Cox, as well as under Tober-Lebeau.
So let me interrupt you for a moment. So your position is that this is a crime of moral turpitude if you forget to register?
Absolutely, Your Honor. Considering the gravity of the offense, again, drawing the contrast between administrative transgressions in other contexts and administrative transgressions when it comes to maintenance of a sex offense database, this is absolutely turpitudinous. And drawing back to your co-justice's question on moral reprehensibility, at the end of the day, the legitimate and compelling public purpose behind these statutes is to ensure that local populations remain aware of sex offenders coming and going from their community. So to register one time is insufficient. Mr. Politis had an obligation to renew his registration every year. And the court also stated in Tober-Lebeau, a willful failure to register by a sex offender who has previously been apprised of his obligation to register implicitly involves evil intent, even if the obligation may have been forgotten. The respondent will urge you not to conflate Mr. Politis' conviction with statutory rape because they're separate offenses. But Your Honor, consider what Smith v. Doe stated. Sex offender registries protect the public and may be retroactively enforced because of the public's interest in being alerted to sex offenders' identities and locations.
Thank you, Mr. Rosen.
May I ask one more question? Would you mind?
Please.
You're stressing the gravity of the offense, certainly stressing the gravity of the offense. And so let me just ask you, when we consider that on the failure to register, should we loop back and consider that that's particular conviction for statutory rape only in Troy, only required that the victim be under 17 and not 16, as is the case with the federal counterpart?
No, Your Honor. Because it was a strict liability offense, it does not matter whether or not it was what the age is of the person that participated, whether it was consensual. It's simply he violated the statute, and that is certainly.
It's equally grave. Is that your answer? Either way.
Yes, Your Honor. May I very briefly conclude?
I think you've already concluded once, but you may have 30 seconds.
For these reasons, we maintain that the immigrant's failure to update his sex offense registry was his second crime of moral turpitude, justifying his deportation. Thank you, Madam Chief Justice.
We'll hear from your colleague.
Thank you, Madam Chief Justice, and may it please the court. We also urge you to affirm the 13th Circuit Court's judgment that respondent's due process rights were not violated because he had no liberty interest in this specific matter, and he was not prejudiced because he was not meaningfully deprived of judicial review and had a chance to change his case. 13th Circuit jurisprudence establishes the framework for this issue. First, as the 13th Circuit noted in the instant case, respondent must show that he has a liberty interest in information concerning his eligibility for removal. And secondly, as the 13th Circuit noted in its Odysseus decision, he must prove prejudice by demonstrating that he was deprived of meaningful judicial review and could have changed the outcome of his case. On the first issue regarding the purported liberty or property interests at hand, we would first implore you to remember that in Reno v. Flores, this very court said that judicial restraint in creating new rights is incredibly important. And the existing due process rights created in the removal context were already established by this court in Kwang Hai Chu versus Colding, when it said that what is required is a notice to appear before a tribunal and a fair opportunity to be heard. Respondent purports that the relief purportedly available in this case, 8 U.S.C. 1229 and 8 U.S.C. 1182, give rise to some discernible liberty interest. However, this court also has issued guidance on how statutes can create such a liberty interest. U.S. v. Torres in the Third Circuit applied this court's decision in Greenholz and said that in order for statutes to create liberty interests, they must be governed by substantive criterion and they must bind the executive administering those criteria.
But isn't there a potential distinction, Counselor, between, I mean, I think it's undisputed, there's no entitlement to discretionary relief, but a distinction between whether you have the entitlement to final relief and whether a fundamentally fair proceeding requires that you know that you have the ability to apply for such relief. I mean, the IJ has a special duty to develop the record in these cases, don't they? Particularly when a person, an individual is not represented.
To answer the first part of your question, Your Honor, the Second Circuit in U.S. v. Copeland did hold that there was a—
I very much like those Second Circuit decisions.
I know, Your Honor.
I like the ninth. What do you got from the ninth?
That's coming up, don't you worry.
Right.
The Second Circuit does acknowledge a distinction between the relief itself and the right to request that relief. However, it does not continue the relevant analysis because as the Sixth Circuit analyzed in Hanna v. Gonzalez and the 11th Circuit found in Teffel v. Reno, even if there are those two distinct rights, if you put them up against each other, they're functionally constitutionally, the difference is constitutionally insignificant. As this court held in Olam v. Waikanakoa, the process itself is not a substantive right. The due process has to attach to some underlying interest. And so that means that if the final relief that someone is working towards is still entirely at the unfettered discretion of the Attorney General, there is not necessarily a due process protection on the ability to try and attain that relief.
Counsel, why isn't the interest, as the Chief Justice just tried to tease out, why isn't it just the interest in a fundamentally fair process? You have an unrepresented individual. We're not talking about entitlement to relief. Shouldn't he at least be advised, particularly where the entitlement or the eligibility, I should say, is apparent on the record?
Your Honor, two pieces there. First, there are absolutely protections that do apply to one when they're going through this process. The question is whether the specific information about like being told about apparent eligibility applies. But secondly, to speak to your second point, our contention is that there was no relief apparent before IJ Agamemnon that respondent was apparently eligible for. He was not apparent.
The second is factual about what the record does or does not show in this case. Could I get your, just to be clear on your response to the first question first?
Our response to the first—
Does entitlement to a fundamentally fair proceeding mean that an IJ in this circumstance should be required to advise him of eligibility? Was that a yes or a no?
Not necessarily, Your Honor. A fundamentally fair proceeding, as this court held in Colding, said that there needs to be a notice to appear before a tribunal and a fair opportunity to be heard. And there are circuits that have found that there are these sort of fact-finding inquiries fact-finding obligations by an immigration judge, but to use those as the foundation for a liberty interest in attaining the information about removal, there's no evidence that those fact-finding inquiries have an underlying liberty interest attached to them, because all the liberty interests that hold in a deportation hearing are contained within the hearing itself and not this specific procedure.
Could you speak to whether or not he has a fair opportunity to be heard where he doesn't, in a circumstance where he doesn't know that he is eligible for relief?
Your Honor, that speaks directly to the first prong of the prejudice analysis concerning whether or not he was meaningfully precluded from judicial review. Given the facts on the record, we allege that he did have a fair opportunity to be heard. He was fully aware of his rights to bring evidence before the trial and witnesses and testimony. He was fully aware of his rights to appeal a determination by the immigration judge. He was fully aware of his, the court even offered that he could take the time to go and find a lawyer, and they gave him a list of legal service providers. He chose not to exercise those options. And the important part is that even if there was some error on the part of IJ Agamemnon, respondent knew that he had the right to appeal those decisions, and this court held in Mendoza-Lopez that any error in order to constitute deprivation of meaningful judicial review needs to be so fundamental as to have functionally deprived them of that review.
What about the significance here of the IJ referring to, what was it, you don't have, this is not a pardon case, or you're not entitled to a pardon? I mean, doesn't that essentially communicate that there is no entitlement to discretionary relief? Doesn't it go beyond just the failure to inform, but maybe missuggesting that there's no possibility of relief?
Your Honor, in regards to the pardon language by IJ Agamemnon, as the 10th Circuit examined in Aguirre-Trello, referring to cancellation of removal as a pardon is actually kind of conforms to the immigration judge's obligations to help the immigrant understand the law, because both a pardon and cancellation of removal are unfettered acts of executive grace, essentially. In regards to the information that he provided, affirmative misinformation by an immigration judge can play a role in determining deprivation of judicial review, but there are two problems with this. First, the respondent was fully aware of his right to appeal a determination by the immigration judge. So if he was told he was not eligible, he knew he had the ability to appeal that decision. But secondly, and most importantly, our position is that because as a matter of law, he was not eligible for cancellation of removal, it was not misinformation by the immigration judge when he told respondent that he was not eligible for a pardon.
Why was he not eligible for cancellation?
Yes, Your Honor. Under the stop time rule in 8 U.S.C. 1182, respondent, when he committed statutory rape in when he was convicted of statutory rape in 2015, that stopped the clock on his continuous residence requirement under the 7 years required in 1229. Which means, and we know that immigration judge Agamemnon knew this because he did not just ask respondent if he had been convicted of statutory rape. He asked him if he had been convicted of statutory rape in 2015, the year that would have cut off his eligibility for cancellation of removal. That means that when IJ Agamemnon told him that he was not eligible for a pardon, he was communicating the actual finding that he was not eligible as a matter of law.
Wasn't he also, though, I'm assuming we agree with you on that point, wasn't he also implying that there's no other form of discretionary relief? And there was still the possibility, maybe the IJ didn't have all the information to know, but the possibility of extraordinary relief because of the respondent's spouse.
Your Honor, the specific obligation of an immigration judge to disclose possible options for someone's relief from removal are governed by the apparent eligibility bar that Justice Kristen previously mentioned. Just the fact that respondent was married is not sufficient to show apparent eligibility for an extreme hardship waiver, because an extreme hardship waiver needs to be granted in the event that there are consequences beyond those of a normal deportation. And so
what do we do about, forgive me for interrupting, counsel, but right there in the transcript, you've got a problem, right? Because it looks like he was cut off, wasn't he?
Yes, Your Honor. So IJ Agamemnon in the initial questioning phase did cut off respondent from answering the question. But the important element there is that later on so IJ Agamemnon 1 had previously told the respondent that he would have the ability to call testimony, bring in evidence, witnesses, all these other elements. So he knew he had those rights. And then later, when IJ Agamemnon returned and decided to offer respondent the opportunity to present those arguments, respondent declined, and he waived his rights by saying that he wished to voluntarily return. So respondent, most importantly, knew about all of these rights. He heard this determination by the immigration judge, and he decided that he wanted to voluntarily return to Mount Olympus. And even if there was some further inquiry justified by immigration judge Agamemnon, at a certain point, he has to abide by the wishes of the immigrant in front of him. And he repeatedly asked respondent if he actually wanted to return to the country, and the respondent said yes. So by the time that IJ Agamemnon had offered him the opportunity to present these facts, respondent had decided that he had no interest in doing that. But I want to quickly move to the last prong of the prejudice analysis at hand, which is that there must be some possible change in outcome for the respondent's case. Now, the 13th Circuit applies the same plausibility standard as the 9th Circuit. However, what the Second Circuit in Copeland points out is that the reasonable likelihood test, requiring that a respondent show a reasonable likelihood of attaining relief, is a much better match for these kinds of cases, because the two situations where these kinds of cases are likely to emerge about eligibility for removal are issues with immigration court proceedings or deficient counsel rulings, and deficient counsel rulings use reasonable likelihood. Under the reasonable
Counsel, what Ninth Circuit authority are you relying upon, please?
I'm sorry, can you repeat your question, Your Honor?
What Ninth Circuit authority are you relying upon?
It was the Second Circuit in Copeland, Your Honor.
I'm
Not the
asking
ninth.
about the Ninth Circuit. I thought when you got to this, are you not talking about, you're not relying on Ninth Circuit authority now?
Oh, so Your Honor, the overlying framework of the issue is provided by the 13th Circuit between the requirement there, but under the.
I appreciate the
Okay.
problem, but I'm asking a different question.
Okay.
Do you have Ninth Circuit authority for this proposition? Or are you relying on, are you just speaking to the second?
Oh, so we do have Ninth Circuit authority about the plausibility standard, and we do allege that he fails under the probability standard. The Ninth Circuit cases would be something like Valdez-Novoa.
That's all I was asking. It was not.
Okay. Okay.
You were told deficient counsel before, but in fact, he didn't have any counsel at all before the immigration judge.
He did not, Your Honor. But what the Second Circuit argues in Copeland is that because there is essentially an analogous nature between the types of issues that arise from deficient counsel and the types of issues that arise from, in this case, a deficient immigration judge, allegedly, that the reasonable likelihood standard is the appropriate one. And under reasonable likelihood, because he was categorically unable to get 1229 relief, and because there was no inference on the record that he could achieve 1182 relief, we don't think that it's reasonably likely or frankly plausible that he could have achieved either of these forms of relief. So we satisfy under either test. An additional layer of this analysis can also come from Pablo v. INS in the Ninth Circuit, where they looked at the factors that BIA weighs in terms of positive and negative equities in determining relief from removal. And if you look at those factors, respondent fares very poorly. On the positive equity side, he doesn't have a history of community service or service in the military. He has this one family tie, but there's not much development on the record otherwise. But on the negative equity side, he fares very badly because he has a criminal record where he, as we previously said, he committed a crime involving moral turpitude, and we believe he committed a second one. It also contains an inference of bad character on his part because of the particularized nature of that crime. And so if you take these factors in totality, he has really bad marks on his negative equities and not much on his positive
What
equities.
is your take on how he committed a crime of moral turpitude?
Your Honor, my co-counsel, I believe, fully laid out our argument on why he committed a crime why the second offense constituted a crime involving moral turpitude.
That involved the sexual relation with the with the university student? No, 16-year-old, I'm sorry.
Yeah, yes, we don't, I believe the record indicates that she was not actually a student at the university, but regardless, Your Honor, the record indicates in many places that the first, and it's very widely held across the board, that the statutory rape was a crime involving moral turpitude. And so the complete picture here, Your Honors, is that the respondent was guaranteed what at a minimum was required by the due process clause. In this case, he did not have a liberty interest specifically in information about eligibility removal. Even if he did, he validly waived his rights for that removal and therefore was not deprived of meaningful judicial review. And even if all of those arguments fail, he could not have plausibly or reasonably likely changed his case.
Okay, I know your time is up, but the essence of removal itself, that was for failure to register, is that correct?
That was the second offense, Your Honor, yes.
Okay. All right.
May I briefly conclude?
Yes, you may.
Thank you, justices, and we urge you to affirm the 13th Circuit Court's determination that respondents' due process rights were not violated. Thank you.
We'll hear from the respondent.
Madam Chief Justice, and may it please the court. My name is Lauren Murtag, and alongside my co-counsel, Alex Karahalios, will represent the respondent. Respondent seeks to affirm the appellate court's holding that failing to register as a sex offender is not a crime involving moral turpitude pursuant to removal, and reverse the holding that respondent did not have a due process right to be made aware of discretionary relief from removal. I will be presenting on the first issue of moral turpitude, and my co-counsel will be presenting on the second issue of due process right.
That has to
court
do with the question I just asked about whether failure to register is a crime involving moral turpitude. It doesn't seem that way to me, but perhaps you can elaborate on that.
Correct, Your Honor. So our position is that it is not a crime involving moral turpitude. And we believe that the court should find that failing to register is not a crime involving moral turpitude because the respondent did not have a willful mens rea at the time the act was committed. The conduct itself was not reprehensible conduct because it was an administrative act. And the court should keep distinct the failure to register as an administrative act from the separate act of committing a second sexual offense. Although Congress—
Why isn't this like the Ninth Circuit's decision? And I apologize, I'm blanking on the name, but in the aggravated DUI case, I mean, a person who has had difficulties with drunk driving before is now in the position where he or she is absolutely prohibited from driving, and yet gets behind the wheel and drives drunk. Why wouldn't it be appropriate to analogize this registration requirement to that there's a category of people might debate whether some people should be included in it or not, but a category of people who pose a particular danger to children. There's a registration requirement. Almost every jurisdiction, maybe every jurisdiction in the country has it. These people owe a moral duty to register because of the special danger they are perceived to pose to children. So it's not clear to me that this is not a crime of moral turpitude. Thought about in that way, it seems to count.
Your Honor, I would distinguish these two separate acts because driving drunk has an immediate and direct harm. In that situation, the defendant would not need to take a secondary act for the harm to result. Simply the act of driving drunk has an immediate harm on the society around him. In contrast,
it doesn't necessarily. It's the same risk of harm. That's what we're getting at, right? In either circumstance, it's easy to imagine somebody failing to register presenting a risk of harm because people in the surrounding community are not on notice. And there are people who drive while intoxicated, as reprehensible as that might be, without getting into an accident. So what they're doing really is just presenting the same kind of risk of harm to their immediate community.
yes, Your Honor. The distinction I was trying to make was the mens rea distinction in the second harm. So in the context of driving drunk, I think the argument would be that there would not be a willful mens rea in the act of the crash. However, in this situation of failing to register, for the second act to be committed, it would be a physical act by the defendant. And there's no evidence that this respondent had committed a second act, nor had any intention to. So I'm arguing that the second act in this case would have been willful, whereas in the comparison of drunk driving, there wouldn't have been a second willful act. It would have been the act of getting in the car and driving.
So could I ask a sort of a related question? Because I think the Chief Justice's question regarding the harm to children raises an interesting point because the statute in Troy for statutory rape is different than the federal analog. So should we consider that in this case, he's failing to register after having committed a crime? Perhaps it qualifies as statutory rape. That seems to be uncontested. But what I'm not hearing is anybody engage in the notion or the recognition that for this particular offense, we don't know if the victim was, she could have been 17. She could have been almost 18. Does that play into the circumstances when we're trying to figure out whether or not it is necessarily reprehensible conduct to failure to register?
Your Honor, I think the answer would depend on the approach the court applies. If the court were to apply the realistic probability approach, then I would say, yes, it does impact it because the harm coming from the failure to register would be the risk to society. But to your point, in this situation, the victim was just shy of her 17th birthday. The respondent himself was only 21, and he believed that she was a fellow classmate at university.
But you're looking at some of the facts that we don't know. What we know if we do a pure element to element comparison is that she was in Troy, the conviction is just she's under 18, right?
Correct.
And so go right ahead. But I just want to caution you that if you're straying into facts, you might be losing me because it's contrary to the Taylor approach.
Yes, Your Honor. So we would actually be arguing for the Taylor approach, the categorical approach with that minimum conduct standard. So if the court were to find that the minimum conduct convicted under the statute was not a crime involving moral turpitude, then the conviction should not be considered a conviction of a crime involving moral turpitude. And to your point, we would argue that this is the correct approach because it was used in the Taylor case. Further, it has long been used in immigration law because of Congress tying immigration policies to convictions would suggest that Congress has intentionally limited the power of the adjudicator to the statute itself rather than the underlying facts. And under this approach, were we to look at the mens rea requirement, this is a strict liability statute with no culpable mens rea requirement, suggesting that it could easily be violated by a simple mistake. Under the categorical approach, the minimum conduct which could be convicted would be a respondent who showed up to register, completed the registration, and simply made a typographical error. In this situation, the respondent would not be aware of any harm that possibly could have happened to society and thus would not meet that reckless mens rea standard.
All right, you mentioned that this was found out after a police stop, but supposing he intentionally failed to register, would that make this a crime of moral turpitude or involving moral turpitude?
No, Your Honor, we would argue that that is still not a crime involving moral turpitude because the act itself is still not a reprehensible act. In its essence, it's still a regular.
May I interrupt for a moment? He intentionally fails to register. He doesn't want anybody to find out where he is. You say that that's not a crime involving moral turpitude.
No, Your Honor, we would argue that the crime involving moral turpitude would be the second conviction. So to your point, had someone intentionally failed to register, and then let's say they committed a second sexual offense, that would result in a second conviction. And that second conviction would indeed be a crime involving moral turpitude. However, the simple act of failing to register is an administrative offense and should be separated from the second act. So the actual offense of failing to register would still not be considered that base, depraved, or vile or reprehensible act by society. But to return to the mens rea point quickly, I would just like to mention that the petitioner relied heavily on the Baker v. Barr case in the 8th Circuit. However, in that case, although the court did find that a willful failure to register is a crime involving moral turpitude, the court was very careful in the dicta to separate this offense from simply forgetting. The court stated that in this case, they were able to find it to be a crime involving moral turpitude.
But you would go further than that, though. I mean, I thought I heard you just say that even an intentional failure to register, it's your position, is not a crime of moral turpitude. And I thought the 8th Circuit said clearly society is entitled to impose a special duty on a group of people who've been convicted of crimes of this sort in the past in order to protect a vulnerable group. So you're rejecting that analysis.
No, I'm sorry if I was unclear, Your Honor. We are not agreeing with that part of the opinion. I was simply pointing to a later part of the opinion where they distinguished their holding from one, and they stated forgetfulness would not suffice. So they were saying in that specific situation, the defendant had admitted to a willful violation. However, the court specifically stated that had it been forgetful, it would not have met the mens rea requirement.
Isn't there more than forgetfulness on this record? I mean, if we disagree with you, I understand that you're arguing for the absolute categorical approach, but if we go with a modified categorical approach and follow the cases that are cited in the record about looking at things like the record of conviction, I mean, here we are looking at a statutory scheme where people are notified of their duty to register. We have the sex offender registration form that he filled out. It looks a lot like he was reckless. I mean, this is an obligation that's imposed on him, and within a year of it being placed upon him, he's violated it.
Your Honor, we would respectfully disagree because he did not consciously deliberate the transgression at the time he failed to register. Further to your point that the government does send out reminders would suggest that the government has reason to believe that registrants frequently forget to register and that this forgetfulness would be reasonable and thus not reckless. The respondent had previously registered on the initial registration and the first registration, suggesting that he wanted to be a law-abiding citizen, and that when he moved and simply failed to receive the reminder in the mail, he forgot about it. There's no evidence of any conscious deliberation at the time in which the transgression was made that he was willfully or intentionally failing to complete the registration. Further, for culpable mens rea has long been considered the cornerstone of moral turpitude. Because crimes involving moral turpitude have such a high penalty, such as in this case removal, the court should ensure that the respondent truly had a guilty, willful, or evil intent to commit a base, depraved, or vile act. And this situation simply does not fit that category.
Would it,
So-
Ms. Murtaugh, would it be a crime of moral turpitude if Mr. Polita started working with children?
Your Honor, that would be a separate offense because it would fall under a separate part of the sex offense statute on separation from children. So yes, I would have to look more into the situation, but just based off the facts, I would argue that would be much closer to a crime involving moral turpitude than the situation currently at hand. But that is not
The position is here simply that he forgot and he overlooked his responsibility. Is that fairly accurate?
Yes, Your Honor.
Counsel, could you speak to whether we should consider the registration form?
Sure, Your Honor. So we would argue that the court should not look to the registration form that's outside of the record of conviction and would open the doors to possibly relitigating facts that have already been found. It's important under the categorical approach or even the realistic probability approach to not overburden the court system and not to risk relitigating the facts. Thus, there should be a strict line of which documents could be considered. And as the 13th Circuit Court of Appeals found, that document should not be considered.
So what documents are fair game?
We would say similar to the petitioner, except for that document, anything on the record, including the plea agreement, the transcript, and the record.
The only one you think is not?
Correct.
Okay, thank you.
And to speak to the crime of moral turpitude and the not reprehensible act, we would just like to mention that even though crimes involving moral turpitude is an essentially fluid definition because it evolves with the standards of society. However, what has remained consistent is that crimes involving moral turpitude are crimes of malmum-se, crimes that would be deemed inherently wrong even were there not a statute to deem the crime to be inherently wrong. However, under the current statute of failing to register, a registrant could be convicted for registering on the 6th day rather than the 5th. This goes to show the administrative nature of the statute because there's nothing inherently wrong with registration on the 6th day rather than the 5th, suggesting that this is not a crime of malmum-se. Further, the general public is unlikely to see this to be a crime of moral turpitude for that same reason.
Is recklessness a sufficient mens rea for a crime of moral turpitude?
We would argue that the standard should be that willful or evil intent, suggesting that there was some knowledge and it was intentionally committed. However, other circuits have held that, I believe the Bacour v. Barr court mentioned it, that recklessness in certain situations does suffice.
But you would disagree with those cases?
Correct, we would disagree.
So the context of the aggravated DUI would also not be reprehensible by that standard?
Correct, Your Honor.
Even though
That,
a repeat offender in that case is somebody who is being reckless really with other people's lives.
Yes, Your Honor. The distinction would be that in crimes involving moral turpitude, we're not arguing that it's not a crime. The respondent realizes that he did commit a crime. However, we're simply arguing that it's not a crime involving moral turpitude. To be a crime involving moral turpitude, there has to be that truly willful or intentional mens rea. I see that my time has expired. May I briefly conclude?
You may.
Thank you. So, and for the foregoing reasons, specifically that the respondent did not have a willful mens rea at the time the act was committed, the act itself is not a reprehensible conduct because it's an administrative act. And finally, that the court should keep distinct the failure to register from the act of committing a second sexual offense. I respectfully request that this court find in favor of the respondent on the issue of moral turpitude. Thank you.
We'll hear from your co-counsel.
May it please the court. My name is Alex Karahalios, co-counsel for respondent. This court should reverse the 13th Circuit and hold that a non-citizen's established due process right includes the right to be made aware of discretionary relief for three main reasons. First, non-citizens have established due process or liberty interest in being and remaining in the United States. Second, this right is protected by this court's precedent and circuit court precedent. And third, an immigration judge has a special duty to non-citizens, which includes informing them of the discretionary relief. As a preliminary matter, I would like to state that petitioner fundamentally misunderstands the issue before this court. In his conclusion, he stated that respondent did not suffer a due process violation. I would like to make clear that this is not an as-applied challenge before the court. The issue is whether a non-citizen has a due process right to be made aware of discretionary relief. Therefore, while the facts of respondent's case are persuasive and serve as an illustration, they are not ultimately binding on this court's decision.
So if we agree with,
No,
if we agree,
I'll step back. I'll go second.
so if we agree with you, does that mean that in every case, I mean, does this operate like a Miranda obligation for IJs? In every case, there must be a recitation advising the person in deportation proceedings of discretionary relief?
So, Your Honor, the duty for an immigration judge is actually much more narrow than that because, as petitioners rightly pointed out, this has an apparent eligibility standard. This is grounded in federal regulations and lower circuit case law. In particular, 8 CFR section 1240.11A2 states that an immigration judge shall inform non-citizens of their apparent eligibility for benefits and provide them with the opportunity to be heard on such matters. Second, 8 CFR section 1003.10B says that an immigration judge shall administer oaths, receive evidence, and interrogate, examine, and cross-examine the alien and any other witnesses presented. Those federal regulations establish the narrow duty that an immigration judge has. However, the Ninth Circuit across the board, and in particular Nabaldo Figueroa, has established that the immigration judge has that duty when the record contains an inference of the non-citizen's apparent eligibility. Indeed, this obligation is mandatory and if not fulfilled can serve as the basis for a collateral attack challenge under 8 U.S.C. section 1326D. The Second Circuit has similarly held that an immigration judge has that special duty because of their specific duty and obligation to develop the administrative record, to serve as the fact finder and serve as the adjudicator.
I guess I'm not quite understanding. I mean, this is an odd right, and maybe this is why the majority of circuits have disagreed with the Second Circuit and Ninth Circuit. So if it has to be apparent eligibility, doesn't this mean it's sort of a matter of complete fate, luck? I mean, consider his potential ability to get relief for because of extraordinary circumstances, the need to take care of his spouse. That could have been apparent on the record, or it could not have been. You know, it would be a pure fortuity whether whether that came up during the IJ's proceeding. So why should an obligation turn on something that seems not grounded in any, where some people will be benefited and some not? Or am I misunderstanding?
Well, actually, Your Honor, this goes back to my first point regarding the liberty interest. To reiterate, this court in Yamata v. Fisher held that non-citizens shall have all opportunity to be heard upon which matters that liberty depends, including the right to be and remain in the United States. So we're not advocating here today that the relief itself or even the right to seek relief is a liberty interest. It is rather embedded in the due process protections of the liberty interest established, which is to be and remain in the United States. Because discretionary relief can determine whether someone remains in the United States, it is something that is embedded in the due process protections. If we look to Kwang Hai Chu v. Colding, that is where the due process protection really lies. Instead of it being fortuitous, as Your Honor has validly raised as a concern, it's actually grounded in the fair opportunity to be heard. So in Kwang Hai Chu v. Colding, this court held that a non-citizen's established due process right guarantees a full and fair removal hearing. This includes 3 components. The first is the second is a hearing before an administrative or executive tribunal, and the third is a fair opportunity to be heard in opposition to those charges. So the right to discretionary relief in the first place is protected by that fair opportunity to be heard. In the second place, it's protected by this court's holding in Goldberg v. Kelly, which is that non-citizens are in the part of the due process protection is the right to mount a proper defense. This has also been upheld by the Second and Ninth Circuits.
Counsel, we talked a little bit with the opposing counsel about what it means to have a fair opportunity to be heard, whether you really have that if you don't know that you're eligible for relief, right? But I'm not sure how far this obligation of the IJ goes, and what makes it a constitutional violation, really. particularly in this circumstance, given that I think you've got to grapple with the fact that this particular individual said, I want to return. I just want to go back.
Yes, Your Honor, a few points in response to your question. So if we're looking at the record, again, I'd like to reiterate, this is not an as-applied challenge, but looking to respondent's case as an example. At the record on page 41, he was advised of his right to counsel, and he was asked whether he wanted more time to find a lawyer. On the record at page 42, he was advised of his right to appeal, and then was informed that the immigration judge would be making an eligibility determination. After that, he was asked 11 questions, very pointed questions, that the immigration judge asked him in order to determine his eligibility. However, while that is true, the real issue lies in the fact that when, for example, the immigration judge asked him, you have been convicted of statutory rape, is that correct? He said, yes, but, and was cut off. The immigration judge then on the beginning of the record on page 43 said, sir, please only answer the questions that I am asking of you. He therefore denied him of the opportunity to mount his defense and have the opportunity to be heard in that instance. After that, he said, you are not today eligible for a pardon. Now, the fact of the matter is that whether he used the word pardon or discretionary relief is not the core of the issue, although it is an error that the immigration judge made. The core of the issue is that he essentially said, your case is closed, you are not eligible for a pardon. And now, only after that did he say, would you like to fight to remain in the United States? And only after then did the respondent say, no, I would wish to voluntarily depart to Mount Olympus. So the temporal element is crucial here because the immigration judge only asked him very pointed questions for his own eligibility determination. Then he made a conclusion to the respondent saying that he was not eligible, and only after that did respondent say that he wished to voluntarily depart. Now, we're not advocating that it's the immigration judge's duty to override any sort of desire that a respondent may have to voluntarily return. Indeed, petitioners cite to Guayarteyo, which is a 10th Circuit case, but the key distinction there is that in that case, the immigration judge actually informed respondent that he was eligible for certain forms of relief. And in this case, he did not.
Do you agree with your adversary that he was ineligible for cancellation because of application of the stop time rule?
Your Honor, even if he were ineligible for cancellation of removal, he could have been eligible for extreme hardship. And the fact of the matter is that because he was not given the opportunity to be heard and mount a defense, we will never know whether.
So then are you conceding that he was not eligible for cancellation?
Sure, Your Honor, but I would also like to point out that this, again, is not an as-applied challenge. So even though, as applied, if he weren't eligible for cancellation of removal and the immigration judge correctly came to that conclusion, he still could have been eligible for extreme hardship. There were a few factors that indicated he might have been eligible for that relief, but the immigration judge never made it apparent, or never informed him, rather, that he may have been eligible for that relief.
What were those factors? I mean, I know that the fact that he was married is in the record. Was the immigration judge otherwise made aware of anything that would have indicated he might be eligible for extreme hardship relief?
No, Your Honor, he wasn't made aware of any other factors, but he never gave respondent the opportunity. And that's really the core of the issue here, is he never gave respondent the opportunity to develop the issue. Now, of course, we can't always look retroactively, but if we're looking at this case, I think the fact that respondent's husband died soon after he was deported to Mount Olympus could indicate, well, of course, it wasn't available to the immigration judge at the time, but looking back, it could indicate that perhaps the respondent's husband was sick, perhaps terminally ill, but he never had the opportunity to voice that. We, of course, don't know that for sure, but this is all to say that without that opportunity to be heard, we will never know whether or not Mr. Politis would have been able to remain in the United States.
I have
We've got other cases.
take than what you're presenting, because I'm looking at the transcript. I see the judge as asking Mr. Politis, even if the charges are proven, that does not mean you must be deported. You could be eligible for a pardon. I will tell you if you are eligible for a pardon. And then he asked, do you understand? He said, yes. Mr. Politis says yes. Then the judge asked, very well, I should tell you, you have a right to be represented by counsel. But if you don't have one, I can get one for you, or I can see that you are represented. Do you understand? Do you want time to get a lawyer? The answer is no. It seemed like the judge was very concerned about having Mr. Politis understand what rights he has.
Well, Your Honor.
Take a different view.
Yes, Your Honor. Well, one point to that, the right to counsel in particular, although non-citizens in removal proceedings have the due process right to counsel of their own choice at their own expense, they do not have the Sixth Amendment right to government subsidized counsel. In reality, only 14% of detained respondents appear in court with counsel, and 37% of non-detained have counsel. So the fact that they do not have a constitutional right to government subsidized counsel, and the fact that the majority of respondents in immigration proceedings actually appear pro se, inform the special duty that the immigration judge has. Now, I would like to point out that the petitioners have argued that we are trying to create a new right. This right is not new. It's not something we're created. It's established in this court's precedent, in circuit court precedent, and in federal regulations.
Could you verbalize that right for me, please?
The right to be made aware of discretionary relief is something that is not new. It is already protected in due process, even if not explicitly held by this court.
So counsel, right there. In some circuits, there is such a right if it is apparent from the record that there may be eligibility. And so I don't know of any circuit that sweeps as broadly as I think you're suggesting. So if you could circle back to our Chief Judge's question at the outset, is this an advisement then that you would require across the board, or at what point is this right triggered?
So, Your Honor, to be clear, the right is not so expansive. We're not arguing today that the immigration judge essentially has a duty to inform the non-citizen before them of all of the forms of discretionary relief. If
you would tell me what you are arguing, because I know what you're not arguing, that would really help me. Yeah, in response to the question you were just given by my colleague.
Yes.
How would you define the right?
I would define the right as the right to be made aware of apparent eligibility for discretionary relief.
Okay,
so this is
apparent eligibility. So
yes.
So let me get to the problem that was raised just a minute ago about the fortuitousness of that, given that we've got, as you indicated, a whole lot of people in this kind of proceeding who are representing themselves, and often, by the way, speaking through an interpreter. So what do we do about that?
Well, Your Honor, I think that's all the more reason that respondents should prevail today, because the due process protections are all the more important, even if less stringent as compared to criminal proceedings. So if we're talking about the right in particular, the duty in particular, we're going to have to narrow it at some point in order to maintain efficiency. We're not, again, advocating that an immigration judge has to explain the entirety of immigration law. However, if there is apparent eligibility, it is the duty of the immigration judge to inform the non-citizen of such. As a practical matter, if we're looking at it, we can look to respondent's case as an example. He said to respondent, I'm going to make an eligibility determination. You appear to be eligible, for example, for 1229B or 1182H. I will go through now the eligibility determination and say, here are the questions that I'm asking of you to make that eligibility determination. And before coming to the conclusion that he was ineligible for a pardon, he would then give the respondent the opportunity to mount his defense.
But what in this record, I mean, I realize that this is not an as applied argument you're making, but I'm wondering if the argument you're making benefits your client. I mean, if he was not eligible for cancellation because of the stop time rule, the only thing he would be eligible for potentially is extraordinary hardship relief, as I understand it. And you're saying that there was nothing in the record that alerted the IJ to the fact that he might be eligible for such relief, other than the fact that he had a relative in the United States.
Yes, Your Honor, while that is true, he also never had the opportunity to mount his defense and to fully be heard. He was told, you are not eligible for a pardon. Now is your time to fight, which is essentially the same as a judge in criminal court saying, I've found you guilty. Would you like to challenge me? Somebody who is appearing pro se and doesn't have that intimate familiarity with the immigration laws. That is the very reason why immigration judges, like other administrative law judges, have that special duty. They have the special duty to develop the administrative record and to serve as the fact finder and adjudicator. And
how many circuits recognize that special duty?
That would be 2, the 2nd and the 9th circuits, Your Honor. And so
it's a very high burden. It's a very high burden to show exceptional circumstances here. And what about, even in the 9th Circuit, there's some case law approving, or I should say affirming, circumstances in which this type of relief was denied, even where a spouse was very, very ill and the IJ knew it. What about that?
Well, Your Honor, again, I would like to reiterate, this is not an as-applied challenge, and regardless of the plausibility of the relief itself, the issue before the court is whether the respondent has the due process right to be made aware of that relief.
Right, and we're trying to get at what triggered that here, and when is it triggered? And so I just want to give you one more shot to try.
Okay, the right is triggered at the outset. It is inherent in the due process protection. A non-citizen in removal proceeding has the right to be and remain in the United States. That's a protected liberty interest established by this court. I see my time has expired. Do I have leave to answer your question and briefly conclude?
Please go ahead.
Thank you. So we have the established liberty interest. We have the due process protections established by this court to a full and fair removal hearing, including the fair opportunity to be heard. The second due process protection is the right to mount a proper defense. Together, those inform the right to be made aware of discretionary relief because a non-citizen in a removal proceeding cannot mount their defense without having all opportunity to be heard on issues upon which liberty depends. But they cannot inform that issue. They cannot mount their defense unless they are aware of all of the possibilities. And that is why the immigration judge has that special duty to inform them if they are eligible or not and give them the opportunity to be heard. The Second Circuit in U.S. v. Copeland held that without that opportunity, respondents are effectively foreclosed from defending themselves and are denied judicial review. For the foregoing,
I'm sorry. I just have one question. I interrupted.
That's okay.
Okay, just one question. This has to do with the dialogue in Judge Agamemnon's courtroom, and he says, straightforward to your client, what I'm saying is that if you want to stay in this country, this is the time to fight it out and try to remain. Do you understand that? Doesn't that suggest that the immigration judge was trying to help your client? If you wanted to stay in this country, this is what you need to do?
Your Honor, respectfully, even if he were trying to help my client, he still did not fulfill his special duty to my client, which was to give him the opportunity to be heard and make him aware of apparent eligibility from relief. So although he was trying to help, again, the temporal aspect of telling him he was foreclosed from obtaining relief, telling him his case was effectively shut, and then giving him that opportunity is counterproductive. And this goes to the equity issues that are at stake when you have proceedings in which the majority of respondents before immigration judges are appearing pro se and do not have the intimate familiarity with immigration laws that immigration judges do.
I understand that, but in response to the judge's statement, your client says, I understand, I want to voluntarily return to Mount Olympus.
Yes, Your Honor. And again, I would say that he only stated that after he was told that his case was effectively shut. He only stated that he wanted to return to Mount Olympus after he was told he was ineligible for a pardon. I would argue that on the record at page 42, when he said, yes, but he did attempt to defend himself and he did attempt to try to fight and remain in the United States, to which the immigration judge responded, please only answer the questions that I ask of you. When he was denied that opportunity to defend himself and he was told that he was ineligible for a pardon, he felt that he had no other option but to voluntarily depart. And that's why the immigration judge's special duty is so crucial. And part of the due process protections, the special duty that they owe to non-citizens to make them aware of apparent discretionary relief. For the foregoing reasons, we ask this court to find in favor of respondent. Thank you.
We'll hear rebuttal.
Everybody hear me okay? May it please the court. 3 points on rebuttal, Your Honor. First, respondents concede that we are allowed to look at the plea agreement under the analysis for CIMT. That plea agreement contains respondent's signature saying that he understands that if he does not comply with the terms of his release, that he must comply with the Troy Sex Offender Registry, which a signature that says that he is acknowledging that if he violates that agreement, he could face up to 10 years in jail. Under this one document that we have in the record, that is more than enough to demonstrate that he had knowledge of what he was going through. And just take a step back, Your Honors. When you are on the sex offender registry, it follows you in your everyday life. It determines where you can travel, it determines where you can live, and it can determine where you can work. The notion that something—
Counsel, forgive me, but my understanding is that his knowledge of this requirement is not contested.
Yes, Your Honor, but the idea of the pervasive, the pervasive nature of the sex offender status on someone in their everyday life is just to say that it is extremely unlikely that he forgot and therefore did not have knowledge. On to the second point on rebuttal. Our opponents concede that he was not eligible for cancellation of removal. So this all comes down as to whether higher questioning would have met the apparent eligibility threshold for extreme hardship specifically. And that comes back to essentially the transcript of the record before us, which our opponents pick and choose which parts they want to look to. Respondent said that he understood that he could offer testimony, bring up witnesses, cross-examine witnesses by the government, and provide evidence. He said he understood that if he wanted a lawyer, the court would wait for him and allow him to go get a lawyer. He said he understood the fact that if the immigration judge made an adverse determination, that he could appeal that determination. Even if this isn't an as-applied challenge, what this case demonstrates is that the existing procedural safeguards, without adding the additional due process aspects of the duties that respondents discuss, is more than enough to meet the standards set by this court in Colding, where they said that you need a fair opportunity to be heard. Respondent had a fair opportunity to be heard because he was aware of these rights, and the judge let him say it was merely continuing questioning later. May I briefly conclude?
Yes, you may.
Thank you for your time, justices, and we encourage you to affirm the 13th Circuit's court, reverse their judgment by affirming their decision regarding due process and reversing their decision via CIMT. Thank you so much for your time.
Thank you. That concludes the case to be argued today. The judges will retreat to conference, and I'll ask the clerk to adjourn court.
Supreme Court of the United States will now recess to deliberate. Court will resume in approximately 10 minutes.
Before the court resumes, the competitors wish to make a few brief remarks.
I guess I can start. I just wanted to say to my family and friends watching, thank you guys for supporting me. Alex watching, you know, you almost got us eliminated last night because I followed some of your advice, but I'll forgive you for it. And to Smita and to my parents, thank you for all the support.
Yeah, just echo all that. Thank you so much to Alex for all of your help coaching us, and to Smita Ghosh, our faculty advisor. You've been incredible, and want to thank family watching at home in New York and friends as well. Thanks for tuning in and being supportive.
Thank you to everybody who's here watching me. I know I have my family, my friends, and Major Dana Newman, who was our one of our coaches. She stayed through all of our rounds and was incredibly helpful and supportive, and we so appreciate your support. Thank you.
Just to echo what Alex said, thank you to all family and friends at home watching, but especially Coach Dana Newman. Your support meant so much to us throughout the process.
Thank you for that from each of you. I see that our judges are starting to return. So once the court is ready to go, Clerk of Court, Alexandra Gray, will announce that we have resumed session. Thank you.
The honorable justices of the Supreme Court of the United States have returned, and the court is resuming session.
What fine arguments. That was a lot of fun. You guys have put a tremendous amount of effort and wonderful job on all sides. We wanted to give you a little bit of feedback. So we'll start with Judge Kristen and then Judge Fuentes, and then I'll take it up again.
I just want to start by congratulating both teams at battling your way all the way to the final round. It's quite something for both of you to be here, and it's easy to see why you both made it. That is to say, why all four of you made it. It's really been a pleasure. It's been a lot of fun. Very apparent that you put in a ton of time preparing. Very apparent that you know the fact pattern and the law very well. So thank you for all of that hard work, and thank you for the organizers too. It's been really a pleasure to participate. I want to say that the other thing you have to look forward to is that it's all downhill from here on out. You probably never have an argument as complicated or logistically challenging as this one. So yay. It's difficult. We've at the appellate court have been really proud of the fact that we've been able to continue, and lawyers too have been really adaptable, but it's different. And it's different in particular, especially because you can't see the peripheral vision and get the cues of when we want to ask a question. And so then I'm afraid on our part, we just have to sort of barge in and hopefully remember to at least excuse ourselves for interrupting you, but there's no particularly seamless way to do that. I think the best oral arguments are ones where there's an engaging conversation. And I think you all did that. It's really important that you demonstrate flexibility to be able to leave your prepared marks aside and answer the questions we want. And I noticed a couple of you in particular did the thing that I only typically am used to seeing from very experienced practitioners. And that is that when I ask a question, you stop and sometimes even pause for a minute, which tells me that you're listening. And it tells me that you're thinking about it. I'm really trying to engage with me in a conversation about the case. A couple of you did that. And I don't know that I noticed one way or another, maybe all of you did it, but I was just so surprised and delighted to see that in the conversation. Mm-hmm. The other thing that you did, I think, is recognize that when we have a question, even though it might not be the question you want to hear, even though you think we might be going to your weak spot, and of course the pattern was written so you both have weak spots. That's the luck of the draw. But usually it takes considerably more experience than all of you have to recognize that you want to know what's on my mind. Because if I think that an argument is circling the drain, I'm giving you an opportunity to answer what's bothering me. And that's a golden opportunity because you're not going to be in the conference room when we go back to argue the case. So I think I'm often frustrated, and I often think people, lawyers, miss an opportunity if they try to steer my questions back to the strong points that they really had on their outline. You all didn't do that. You did a really great job, I think, of trying to engage in what was on my mind. So congratulations and thank you. I've enjoyed it very much.
Yeah, I mentioned before to my colleagues that I heard an argument in the U.S. Supreme Court several weeks back, and you know, you got the sense that it's a little different than what we do. But I wanted to tell you that because I was amazed at how good you guys are. And I think you're ready for prime time if there is such a thing. The mastery that you had of the subject, I think, was phenomenal. Your presentations were really good in the sense that you were representing clients. Now, we may disagree with you, we may not, but I think that all of you represented your clients very faithfully, very forcefully, and with full knowledge of the subject. And I say that also to say this is a tough decision as to who wins. Very, very difficult to pick a winner here. Now, what happens is, you know, I go with my colleagues to another room and then we kick around the arguments and then we decide, you know, we vote on who's going to prevail and who's not going to prevail. And I have to tell you, that would be very, very difficult in this case. And that's how good all of you were. Your mastery of the subject, your presentation was just excellent. So I'm happy to be here. I think you guys all did really, really great. And I think you all have incredibly bright futures ahead of you. Want to wish you the best of luck.
Yeah, I'll echo these thoughts. You know, I've been, before I became a judge, I was a law professor, and I have taught many students and heard many moot courts over many years at this point. This is one of the most evenly matched teams and one of the best set of teams that I've ever seen. It's clear that you guys have been working hard and that this is really a wonderful competition. You've gained a ton from this because this very specialized thing that you devote all these hours to, you only learn to do well at the level that you're now performing by practicing, by doing it. And going through it, the same problem over and over is one of the best ways to learn about what works and what doesn't work. I want to say to both of you, one of the things that I didn't like about both teams, one of the things I didn't like about becoming a judge is in the professor world, when there's a great argument, you know, at the end, where the person is really fluid and they're engaging a conversation with the court and they know the record and they're so helping us come to good decisions. In the moot court world, you can say, wow, really well done. And that is not something they like us to do at the Court of Appeals. So sometimes you see a really great argument in the real world and it's just magnificent. And sometimes that argument is even going to lose because, you know, the law and the facts have something to do with the outcome. And you just trust that you can, that the lawyer in front of you knows that he or she has done this great job. And I think they do, because it shows in our opinions and in our reactions on the bench how much service they do to the court when they do that kind of work. Great arguments. They're slowed down a little bit. You get a lot less information about reactions, and so the Zoom thing slows down. So in an interesting way, it gives you a little bit more time to develop your thoughts than I would say is at least common on my bench. So I've noticed that I can absorb the structure of the lawyer's arguments. That was true today. You guys spent a lot of time thinking about the structure of your arguments, and I thought you made very good choices in the main. One of the strengths of oral argument is you have these ideas. These are the points that I really want to make sure I make during my argument. You're going to be asked questions, but you want to always answer those questions, which you guys did. But you don't want to give up making those. You don't want to be so led by the court's questions that you don't make those affirmative points that you thought were very important for the court to understand about your client's case. And I over the years have come to describe this as the pivot, right? And there's the graceful pivot to, I've answered the judge's question, now I'm going to pivot to another. There's the graceful one where the judge doesn't realize you are leading the conversation in a way. And there's this sort of graceless one where, well, Judge, I'm going to move on now. You guys were very gracefully moving among the various points you want to make. So just really, everybody that listened today, you guys, you'll learn a ton. Very fluid, just wonderful. Very tough decision. We don't like this part, especially today, but we have conferred, and we've been charged with choosing a winning team. And in this very, very well-matched competition, the winning team today is the respondents team.
Congratulations, everyone.
Yes, congratulations to everyone, and thank you for the invitation to the competition. Turn it back to the organizers at this point.
Thank you so much, Chief Judge Livingston, and to both of the other judges on the panel as well as to all the competitors, and congratulations to the Virginia team. You all did great, and the petitioners did great as well. I know I'm supposed to make closing remarks at this point, but it's difficult to match all that great praise that just came from the judges. So with that, I will thank you all for coming. And one note to the judges, I forgot to mention this earlier, but if we could reconvene in the deliberation room, that would be fantastic, just for a few moments to conclude. But again, thank you all to everyone who came. This was a fantastic event, and we will be in touch with all the competitors as well about their awards. Thank you.
Thank you all, Your Honors.
Thank you, Your Honors, for all the
Thank you, Your
feedback.
Honors.
Thank you very much, Your Honors.
Great job.